we'll continue our conference and come yet a little bit closer to our everyday life of arbitration. Our next speaker will be Falco Kreis. Falco Kreis is a dispute resolution expert at CMS Germany, acting in national and international cases. He should have been with Markus Kaularts, but Markus Kaularts had to cancel this morning. But in wise anticipation, we had two speakers for this slot, so Falco Kreis will speak for both of them. He comes from the arbitration world, but he works very closely with Mr. Kaularts, who comes from the IT world. So they form a perfect team and have specialized in new business models based on future technologies, artificial intelligence, Industry 4.0, fintech, Internet of Things, big data. They also, and that's probably the most important aspect for today, they are the authors of the blockchain arbitration rules, and they are currently establishing the appropriate arbitration institution to make arbitration proceedings attractive for technically complicated mass proceedings. Mr. Kreis, I'm very happy that you are here, and you have the floor.
Good afternoon, everybody. I'm very happy to be here, and I'm trying to cover the technical issues which were supposed to be delivered by my colleague Markus Kaularts as appropriately as I can as a lawyer. There will be a certain overlap between my presentation and the presentations you've already heard, as well as the presentation you will hear from the colleagues of MME. So this means that at certain points I will move a little faster, where I think that the issues have already been covered or will be covered at least. Whereas on other points I might elaborate a little further than the actual presentation reflects. So as a first outline, in the recent years there's been much talking going on about software and technology in the legal industry in general. And I think it's important as a first step maybe to demyth some of the hype that has been going on about legal tech in general, and also to give a slight idea about where we actually are in terms of technology in the legal market. So there are a couple of statements that have been made in the past about specific applications of software in the legal market. And of course there are positive as well as negative examples. I've just picked out a few, which I think put some of the hype, as we call it, into perspective. As for starters, in terms of artificial in general, or AI, Google produced a Go computer. So Go is a board game, a bit like chess, but in essence even more complicated than that. So it's very challenging to produce software that is good at the game and that can compete on an international level. So they have achieved that, so everybody thought, at least in 2016, where the software performed very, very well against top players internationally. Same was the case in 2016 with LegalBase. There was a German platform which offered legal advice mainly to consumers on an online platform. So in fact, the successor of AlphaGo, so the first 2016 Go computer, the successor participated in the World Championships and lost pretty much every game. So even though one would think that the successor would be even more advanced, and it probably was from a technical point of view, as it turned out, we aren't quite there yet in terms of AI. As for LegalBase, and many other legal tech startups, they went bankrupt after pretty much a year in business. Then we have Ask Kelsen. There was also a German platform, I think, that was supposed to give you AI-based information and solutions for legal problems. However, as was found later on, the software mainly copied answers that were given by actual lawyers in a forum called Frag ein Anwalt.de, so another German platform. So there wasn't much AI going on, in fact. And then we had in Germany an undertaking called the rental control that was introduced by the German legislature in order to limit the increment in rental prices. And very soon after that law was introduced, several startups rose, so to say. One very successful one in the beginning was Miethelden. They offered to assess rental contracts and then tell you if they were compliant. They were even state funded. They were considered one of the most promising, at least, startups in that sector, but they too went bankrupt. So we made two hypotheses. That means, first, we as lawyers, at least as of now, are not obsolete, not just yet at least. Especially when you consider very complex cases, legal questions which require a bit more than just copying answers that you can put in a database. However, the second hypothesis is that software in general, and this will lead us to smart contracts later on, can do quite a bit in the legal work and can help us as professionals, especially in cases and tasks which are very repetitive, a bit redundant, where it's very much about computing power and not about the complex task a lawyer has to fill in. So what we say is that software does offer a great opportunity, but not as in it will replace the lawyer just now, but rather it can help us as practitioners, as professionals, to focus on a more complex task, the one task for which our clients pay us actually, and then source out certain other tasks which can be dealt with by software. So initially I intended to explain what a smart contract is, but I suppose that after the first session you already have quite a good idea, so I will go rather quickly through that. So obviously in the past 100 to 150 years we've had quite a bit of innovation. We've talked about Bitcoin, of course, but then again there's a case where not much has happened, one would argue at least. Dispute resolution. Courts and also arbitration proceedings look pretty much the same as they did a couple of years ago. So the question is, that innovation that smart contracts brought to us, could that maybe give us the opportunity of moving forward in terms of dispute resolution? So first off, a smart contract will not be able to solve an entire case. A smart contract will not be able to assess legal questions, because that would require AI. However, a smart contract, and we've talked about the link between smart contract and the real world, which will come into play later on, this is something where a smart contract could actually help the deciding body, for instance, a court or an arbitral tribunal, to decide a case or to work on a case. Provided, however, that this smart contract has a link to the outside world and can be fed with the information which is required to decide the case or the factual questions. So we've heard this one too. Smart contracts are neither smart nor are they contracts. It's a software, of course, and it is used to perform an action. So if there's an underlying contract which sets out an obligation, the smart contract can be used to perform an obligation under the contract, of course. However, only if predefined conditions are met and if the smart contract can be fed with the relevant information. And this is the third vending machine you see today. obviously it's a very good example because you feed something into it, the smart contract processes it, and gives you something. And this is the action the smart contract is required to do. However, maybe it gets a little more concrete with another example. So for instance, if you buy a ticket, flight ticket, generally you pay the airline, you get your ticket. You fly, and then either the flight is on time, or it takes place, or it doesn't. So what I want to say is that there might be cases where, even though you have paid the entire amount to the airline isn't entitled to the entire amount. So in the regular scenario, you would then go to the airline and say, my flight was delayed by 5 hours, so please issue me a refund. And this is where smart contracts can come into play. What if we didn't pay the airline directly, but rather put the money into a trustee? And the trustee in this case is a smart contract. Because we heard from Lucius earlier, smart contracts on a blockchain basis, it makes sense where there's a lack of trust. So we can place the payment into the smart contract to hold on to it. Then we get our ticket, and then we wait what happens. This is the underlying code. If the flight's on time, the airline will get the money. However, if the flight is delayed, the money will be distributed. This is, however, only possible under the premise that, as we've also discussed earlier in the first session, if this particular scenario is embedded into the code, only then it works. So that brings us then to the question, provided that this scenario is embedded into the code in principle, do we really need any more dispute resolution? And as we already discussed in the early afternoon, yes, there will be cases that will give rise to disputes. So this is a smart contract. We have the code and we have the underlying contract. The contract says that if the flight is delayed, the customer will get 25% back. This is also reflected in the code. And only if that's okay, yeah, so that should actually be here. And only if the contract, or the law for that matter, and the smart contract, or the code of the smart contract, are coherent, then it works properly. If it doesn't, we might have a dispute because the smart contract does something which is not intended to do. The same is true if there's a case which isn't embedded into the code. Say, as in the example, this rule does not apply where a certain discount has been offered previously. So the ticket price was only 100 euros, the rule doesn't apply. And we have a case with which the smart contract can't deal. This is another case where the smart contract itself can't handle the information it gets. Something hasn't been foreseen when writing the code, and will need maybe a third instance deciding on any dispute arising out of that. The third point, and I think we already discussed this too, is where there are legal terms such as fault, responsibility, appropriateness even. This is something which, as such, cannot be put into the code, I'd say. So this is something where a lawyer, an arbitrator, a judge would come into play. So these are by no means all, but I think the main issues that can arise if a smart contract performs an obligation under a contract. So we already covered the first three. The other ones are if the smart contract is fed wrong information. So we've again talked about the link between the smart contract and the real world. Obviously these things exist, and they're called, in terminology of smart contracts, they're called oracles. So when there's an oracle, it's an interface that connects the real world outside with the smart contracts, and that feeds the information into the smart contract. in the first example with the airline, for instance, there's an interface that's being fed by GPS data by maybe the computers of the airline that feed the smart contract the information whether the flight was on time or not. However, if that information is wrong, then the smart contract can't perform the obligation properly. The same is true if the smart contract is fed with inconsistent information. So where does that take us? The thing is, there will always be bugs and errors, and there will always be cases that will arise to dispute. The only way to circumvent bugs in smart contract is not having smart contracts at all. And at least our premise today is that this is not an option. We will have smart contracts. Then again, we had the topic of hacks. Of course, it is technically possible to hack not just the Bitcoin, but to hack maybe the blockchain. So this is the DAO hack, so to say, one of the most infamous cases where Bitcoin or another cryptocurrency was distributed to a source or to an account where it shouldn't have gone, and it was, I think, irretrievable. So that means in practice that we will need a mechanism to deal with these issues, to deal with cases where a dispute arises between the two parties. And based on this, we've thought of a dispute resolution mechanism that could be embedded into a smart contract. One example for a dispute resolution mechanism that already exists is a dispute resolution mechanism that PayPal provides. It's mainly used by PayPal for eBay transactions. They work very closely together on that. And in essence, it works like this. The buyer buys something, and then he or she can initiate a dispute resolution process. Both parties feed into the system the relevant information, and then have the time to settle the dispute. What's most important is that the entire dispute comes down to a simple question of fact. Where's the money? Where's the product? So what this dispute resolution mechanism provides is not a full legal assessment. It's not a legal assessment at all, for that matter. Rather, it provides a fast and, in these terms, efficient resolution for possibly minor disputes which nobody would ever take to court. Possibility for the parties, if they do not settle the case, is to raise a claim. Then the entire claim will be dealt with by PayPal. They will effectively decide the dispute, and then you can even appeal the claim later on if you're not happy with the result. Now, obviously, this system does not provide for a final solution. It's not binding, especially in consumer cases. It's all standard terms, and therefore you can't make it binding. However, it is used factually by many consumers, given particularly the fact that many sellers are not in the same country as the buyer is. The amounts in dispute are very, very small, so nobody would really think about taking it to court. And therefore, this system provides a possibility to solve these disputes rather quickly and rather easily. So this is, so to say, the heart of the smart contract dispute resolution. It's a diagram of the smart contract with an additional, we call it arbitration library. So first, we start off with a normal smart contract. The parties initiate it, and the smart contract runs. But then there's a grace period after the contract has performed a certain obligation, or has not even after a while. We had the example of a car being placed in a garage, or a diamond being sold. This would be something during the grace period where you could inspect the garage or the car or the diamond if you have bought something physical, which you need to inspect. And if everything's fine, you do not object, of course. But if something's wrong, you do object. And in this case, the protocol initiates the arbitration library. So this is, in essence, the backdoor Lucius was already talking about. This is the backdoor which allows us to go into the smart contract and change potentially the smart contract if it's necessary, or to feed it further information which it doesn't have. So in essence, in our case, the arbitral tribunal acts as an oracle for the smart contract. And this could either be an arbitral tribunal, it could be an expert in terms of expert determination, it could be any dispute resolution mechanism, really. Of course, in this context, we come to certain legal issues. Obviously, where we have an arbitration library and then subsequent arbitration proceedings, we'll need an arbitration agreement. Now, if we only have the smart contracts, then technically the arbitration agreement will be embedded in the code. So it's not written down as such, certainly not on paper, and most certainly not in English or German or Spanish or any language which anybody can read. However, that does not necessarily mean that we do not have a proper arbitration agreement. It really depends on the specific case at hand. If it's a consumer dispute, we'll have to rely on the parties to go through with the proceedings. Where we have a B2B case, one could certainly argue that the arbitration agreement is still in writing in terms of, for instance, the New York Convention. However, as I just said, it's not written out. So there's an issue. We do have an arbitration agreement as such, but it's not in a proper language. It can be decompiled, and then we do have it, at least reproducible. And with that arbitration agreement in the smart contract, we initiate the arbitral proceedings. In this case, the smart contract dispute will be referred to an arbitral institution, for instance, and then the arbitral institution essentially acts as any other institution. It will appoint a neutral, and the neutrals, the arbitrators, will then decide the dispute after hearing the parties. For that purpose, we created the blockchain arbitration rules, and these are, in essence, they mirror, I'd say, any other internationally established arbitration rules. The main differences are that blockchain communication and certain automatisms within the proceedings are already foreseen. So that means the communication between the parties, as well as the referral of the case to the institution and to the tribunal, can be done via blockchain. Yes.
Is that a private blockchain or a public one? And if it's private, who has access to that blockchain?
In this case, it will be, or it is, a public one. But then again, it's something which can be run on any blockchain. So it's technically not, it doesn't need a blockchain as such. However, since most smart contracts run on a blockchain anyways, and we work together with a company that provides certain smart contract services, we already used the infrastructure they have. And then, during the proceedings, and after the proceedings, the arbitral tribunal will issue an award, a decision. And there, we, as an oracle, feeds it into the smart contract directly. That means the decision of the arbitral tribunal will essentially be self-enforcing, provided, of course, that it's something which is already foreseen in the smart contract. However, as we already discussed earlier, we'll certainly not be able to monitor, or at least in my opinion, we'll not be able to monitor and to mirror every single possible case in the code. I think that won't be possible. However, what is possible is to allow the tribunal as a trustworthy oracle to alter the code, either to declare the smart contract even invalid, and thereby just stop it, or amend the code if necessary. And then after the relevant information is fed into the smart contract runs again. You'll go back to the grace period. And if it's expired without any objection, smart contract continues running or performs the obligation it's supposed to. This is not an example of a full request of arbitration, of course. However, it sets out the basic idea. We do not have addresses as such of the parties. We have their IDs, we have their public keys. And they communicate with the institution, they communicate with each other and with the arbitral tribunal via the blockchain. And then the next point will be, what does it mean for dispute resolution in general? So the next point won't be strictly related to smart contracts as such, some of them will be, but mainly it takes up the idea of the smart contract into dispute resolution in general. The idea of having a software with a certain predefined task which it will perform automatically in order to save time and money. Now, in essence, we're talking about automatization of dispute resolution. But then again, it's not black, it's not white. It's something in between, mostly. And it's very comparable to the automatization of cars or autonomous driving. With different levels. Everybody only talks about the car you step into, and then you lean back, have a nap, and the car drives you somewhere. But there's quite a lot in between. And this is pretty much the same with dispute resolution. At the moment, I'd say we're pretty much at level 0, maybe 0.1. But then again, until we'll be fully replaced, there are lots of possibilities where we might be able to embed software and automatization. However, in order to solve any problems, of course, we first have to see where are any problems. So these are only a few of the current tasks, I'd say, with which we have to deal, especially in international arbitration. Cases get more and more complex. That will lead to lots of information which will have to be processed by the party representatives as well as the arbitrators. On top of that, as an arbitrator, you'll have to deal with the additional information the party gives you, which might not be entirely relevant for the case. Then you got international disputes, which bring a number of challenges with them. First of all, just single issues, we have time differences, we have different languages, we have cultural differences with which we have to deal. Then we got contracts or cases which relate to smart contracts, which pretty much mirror the one I showed earlier. Then we got more and more technical cases, arbitrators getting more and more familiar with certain technical issues. This is not only related to smart contracts and IT problems, it's the same with construction. We're dealing with very different and a multitude of very complex technical issues for which we have experts. Then there's a general workload of neutrals. Of course, we know the situation where the first idea for oral hearing is in August, and then you end up in May because this is the first day when everybody is free. So there might be a chance to reduce the workload of the neutrals. And then the next step, which I think is less relevant for arbitration cases, but for dispute resolution most certainly in general, mass procedures. Procedures initiated by a group of claimants against one or several respondents. So then the next step is to think about the possibilities of implementing software and using software to deal with these issues. The question is then, how do I embed software? And for that, I think it's very helpful to first think of certain sets of cases, certain sets of disputes and procedures, because especially different procedures require potentially different software and certainly pose very different challenges. So first we have consensual versus adversarial proceedings. We do have arbitration as an adversarial proceeding. We also have dispute resolution mechanisms like mediation. Now, it's very hard to think of consensual dispute resolution mechanisms where there's no human neutral. A machine mediator is very hard to think of, but in fact there are certain cases, and I don't want to get too deeply into any precise examples because the colleagues of MME will deal with these. But there are certainly cases where studies have shown that people are indeed willing to relate to a machine. So whilst one thing that a mediator cannot be replaced by a machine, there are certain studies that do suggest that this could be done. Then there's one, from my point of view, very essential point. Disputes of fact, questions of fact. These are things that can be dealt with by software. I wouldn't say easily, but I think this is a very, very good case for smart contracts and software implementation in general. If we go back to an oracle where information from the outside world is fed into the smart contract, a smart contract could assist an arbitral tribunal by assessing certain facts and even deciding disputes on these facts. Whereas disputes on legal questions as such cannot be resolved by a smart contract, and also from a technical point of view, I think the level of, or the sophistication of AI we have at the moment is not yet in a position and not yet able to deal with these, at least not on a sufficient matter. And then we have the full automatization against only assisted dispute resolution, meaning we have a software that only supports the parties and the neutrals and maybe the arbitral institution by handling the case and by deciding the case. So in the first example, and I will only go very briefly through these examples because these are already existing systems. So there's double blind bidding, which is a fully automated system where parties are in dispute about a monetary claim, and it only works in this regard. The parties are bidding, they're giving bids, and they're saying, so for instance, a party requests the other party to pay 50 euros, francs, Bitcoin. And then both parties will give their, so to say, last offer. And if these two offers are within a certain range, which can be set rather freely, so the 5 or 10%, then the difference will be split in half and the dispute is considered settled. It's, I'd say it's a very bold attempt, but it's been around since I think the 50s or 60s. So the system isn't new, and it is actually being used. Not very often, not in very big cases, obviously not in complex cases. But it is a system that shows that parties in general are willing to sacrifice the quality of a decision in certain cases against time and cost efficiency. Then we got communication support. We got online platforms that allow the parties to communicate with each other, and a chatbot essentially moderates the discussions in terms of settlement negotiations. Common agreements databases that also already exist, where it's basically a check-the-box system where a party says, or two parties say, we want an agreement that regulates this and that, and then software provides examples for an ultimate agreement. And that, of course, can be transferred onto settlement agreements, saying that parties have a settlement in principle, and then they feed it into a machine, into software, and the software evaluates the settlement and tries to optimize it. So there's one software that does that. Unfortunately, it's a pay-only software, so I haven't tried it because it's rather expensive. And I've not heard anything on it, how good it works. But I reckon that it's still in the very early stages. And then again, the question is, where does it take us? And I hope that the colleagues from MME will then build on top of that and tell us not only what's already there, but also where the already existing systems are going. We've got the same example for adversarial proceedings. We've got a unified domain name dispute resolution policy. This, in essence, doesn't handle the case. It's a self-enforcement mechanism where parties are in dispute about a domain name, which is used potentially without a proper interest in the domain name. A party can claim in front of the panel, and then the decision, if the domain is to be deleted, will be self-enforced automatically. We already covered the PayPal dispute resolution. We have crowd justice. We've seen that on one of the other slides already, at the example of Kreis, I think. UJudge is another system which works similarly, and I will not go deeper into that because I think you two have that covered. And then we got to smart contract arbitration, the one presented earlier. The next step, or another approach, would be to analyze an arbitration proceeding or any dispute resolution mechanism at every different stage and see where is there a potential for software to make the life for parties and neutrals easier. With the commencement of the arbitration, that relates directly to the smart contract arbitration. I trigger a smart contract, I object to the performance of the smart contract, and the smart contract directly sends the dispute to an institution or a neutral. A potential application could be the appointment of neutrals. Now, we've already heard a couple of times that blockchain systems provide a certain amount of not only neutrality, but also confidentiality, and you can only be identified in essence by your public key. That means it could be possible to appoint a neutral from a database, and by only seeing the relevant information based on the blockchain, he or she might not be able to conclude who the parties are, and therefore, by not knowing who the parties are, any questions of partiality might become not necessarily moot, but maybe less relevant. Fact gathering, this again relates to the topic of oracles. Depending on the concrete dispute, we've talked about we've talked about the tanker example, that tankers are tracked and weather data is tracked and dealt with by software. That could also be done upon request by the arbitral tribunal, where, for instance, if it is weather data which is relevant, and there is a trustworthy other oracle which gathers the information about weather, this could be done automatically without the need for any further assessment. And then we've got many other cases. So I won't go through each and every one of them. That, from my point of view, do give us the opportunity to implement software to a certain degree in the resolution of disputes. Most certainly, as far as facts and factual questions are concerned, I think the technical possibilities we have at the moment do offer the possibility to deal with these questions. Whereas Legal assessment, not so much just yet at least. So this is the question which brings us back to the very first slides about the hype of software in the legal industry and in dispute resolution. Is this really the future where we're entirely obsolete? And I think it's not, most of all. However, I think the future will look very, very differently in that, especially neutrals, arbitral tribunals, but also party representatives and institutions will be able to use software to provide, first of all, very, very reliable and also very fast and potentially cheap resolution of disputes. Thank you very much. That concludes my presentations, and I'm happy to answer any questions you might have.
Thank you very much for this interesting overview. The advantage of having only one speaker is that you can catch up the delays, like the difference between the sole arbitrator and the 3 members arbitral tribunal. So yeah, we are almost on time. Do you have questions? We have time for questions.
Hi. I just have one question. How do you ensure that the grace period is not abused of? If anybody could just object to the performance of the contract, how do you make sure that this objection is not abusive? If the loop just restarts after, or how often does the loop restart?
Well, first of all, as I think all the cases we've dealt with today, it's a question of the code first and foremost. It depends what the code foresees, and you could introduce a certain amount of finality, so to say, of the first decision of the tribunal in providing a code that does not allow you to object to facts or circumstances which have already been dealt with. This is, of course, dependent on the question how complex the initial decision was. However, I reckon that especially in rather simple cases, it's rather easy to embed that in the code. And even depending on the interface, how you work with the smart contracts, it is possible to have, so to say, a loop counter, if you will, and say that if there's a decision of the arbitral tribunal, you can object to other things, but not to this.
Hello. One question and a comment. What I understood before your presentation, and I think it's sort of confirmed, is that it's too early now to think of an automated dispute resolution process on the blockchain, at least one that is a legally oriented dispute resolution. And then the trend that is going is more sort of alternative dispute resolution, not necessarily based on the law, based on different types of dispute resolution. Now, my question is, are we to expect really a boost of alternative dispute resolution approaches? Because when you look at the world today, business, the only thing that is not globalized is the law. And it is a major problem because it creates big complicated issues, you need to get lawyers from different parts of the world, etc., etc. So my feeling is at some point, more and more people will be willing to settle for a non-legal dispute resolution approach just to get this whole thing moving and get it running. Because otherwise you need to get out of the platform, these Oracle kind of things you set and then get in again. I don't see it really working in this way. What do you think?
That's actually a very good point. For starters, maybe, I don't think that we shouldn't talk about fully automated dispute resolution. I think we should talk about it and we should think about it. But I do think that we're not there yet. We won't have it yet. That being said, I think you're perfectly right, yes. Especially in the context of complex cases and international cases, depending on the complexity, the potential costs, the legal issues that might arise, parties are indeed, or I would say so at least, willing, as I said earlier, to sacrifice the quality and reliability of a decision for a certain advantage in terms of cost and time. Now, I'm not saying where this line is, but I think systems such as the PayPal system or eBay system, they show us that parties are willing to settle for a not so perfect decision if it means much less work for them. So in that regard, I do really concur with you, yes.
Wouldn't it be the opposite? One way of looking at the law is if, then, you have certain facts, and then the law tells certain consequence. We have legal disputes because the then is not clearly defined, or there are differences about that view. But a typical example is the domain name disputes. You have a certain number of very few possible factual situations, and you have to find the consequence. So the uncertainty of the law can be clarified by contract conditions, and that's what contract conditions do. So wouldn't that be, at least for some types of disputes, precisely the opposite of what we just heard, that you can simplify the solutions which the law provides. Either there are some clear solutions which the law provides, and others you can define by contract. So legal solutions could be easily, not easy, could be resolved. Of course, disputes we see in our practice are more complex, but there may be disputes that again can be commoditized, like the domain name disputes.
I think I'll answer that with yes and no. Yes, I agree. There are certain cases which can be mirrored very good in a database. And of course, every database is just as good as the information you feed into it. But then again, I think this is not a different question, or this doesn't, well, contradict at least the earlier statement. Because if I have a database which provides for a certain amount of cases for a certain legal question, giving an automated decision on this question will not consider the tiny differences of each case. And therefore, I think this will still be a sacrifice in the quality and the exhaustiveness, so to say, of the decision. But then again, I do agree that this can be mirrored. And the more information you feed into it on the one hand, and the simpler the cases on the other hand, allows you to decide the dispute with a better quality.
No, the point I was trying to make is the problem could be on the factual side rather than the legal side. If you take the commodity disputes, the look and slip arbitrations, the consequence is undefined in the conditions or in the law, and then you need somebody who looks at the cargo, whether it's haberized or is proper. So the problem may be on the factual side, and in our arbitration practice, a large part of the disputes are the factual issues, the proper understanding of the facts. So I was making the point in contradiction of saying that the problem is on the legal side, maybe just as much on the factual side. And if you have, in certain types of transactions, it depends on the type of transaction. There may be transactions where the legal consequences are simply defined, and what you need is somebody to determine the facts. When, what happens if, and then what happens is defined.
Well, yes, if the dispute is mainly about factual questions, then of course, yes. And this is the point, because factual questions are, depending on the precise question, of course, are very well suited to deal with on an automated basis, yes. I think the other point was that even complex legal questions, which are not very well handled by software, meaning not at all, even in these cases where you have complex legal cases, the parties might be willing to suffer a bit or to sacrifice a bit of the quality of the decision legally in order to have a fast resolution. So I think, yes, on the factual side, I do agree. A big database with certain examples and cases will help and will give foreseeable results. But I also think with legal questions, which cannot be dealt with by software, parties are willing to simplify. Does that answer your question?
I think it's the other way around.
Fair enough.
Just a question. How do you deal with anonymity on the blockchain, in particular where the result of your work has to be implemented in the real world? For example, you have to give back the car to return the car. Is it possible? Do you have?
Well, I mean, obviously, it's easier if you have monetary claims which are paid by cryptocurrency. So then you can initiate it directly. A car, it depends. A car is usually registered somewhere, and if the registry is linked to the blockchain, then yes, it's possible to assign well, non-legally speaking ownership, but most certainly control. Whereas there are certainly cases where you cannot have a direct link between a good, for instance, and the decision as such. So yes, there are certainly limitations.
But do you plan to break the anonymity, for example, in your dispute resolution system?
I think in certain cases, if you really want to make it work, you have to.
Will it be accepted by the community?
Well, since I'm not the community, however, I do think that anonymity within the system is really treasured, at least at the moment. So I do have my doubts if this really could be acceptable. But then again, I'm not the community.